Okay. Good morning. Welcome to the 12th edition of the Meet the Authors series of the Brussels Privacy Hub, which is linked to the Free University Brussels, the Vrije Universiteit Brussel. This is the second time we do this online. In this online environment, we tried to do it less because the idea was to have a nice lunch and all these kinds of things which we cannot have now, unfortunately. But we have a good audience. We have numbers of participants which we never had before, thanks to this online environment. The Meet the Authors concept is the idea to have a critical debate based on some Socratic questioning. So really an intellectual debate and not just a speech. So that's what we are very happy to have here with us Professor Christopher Kuner, who will respond on all kinds of critical questions on the pieces he wrote. Also happy to have here, I will introduce them later a bit more precisely, Svetlana Yakovleva, who works at the University of Amsterdam and also in the Dutch law firm De Brouw, and also Olivier Mater, Head of International Affairs of the EDPS. Thank you for joining. Behind the scenes, there is also important work done by Laura Drexler and Mohamed Demirkan from the VUB, from the Brussels Privacy Hub. A few household things to start with. This is, as I said, a questioning, a debate, so also the audience can participate in the debate. Not right now, because we start nicely with our panel, but afterwards there is the possibility to participate. And you can, at all the time, raise questions or comments in the chat. If you want to participate lively, then we can ask you at a certain moment and ask you to present yourself. You can unmute yourself and put your camera on. And that moment, you can ask a question and actively participate in the debate. You can also raise your virtual hand, and our back office will ensure that your virtual hand is registered. So far about the household. One other thing I wanted to mention, which I shouldn't forget, is that Olivier Mater is here because initially we had Anna Buchta from the EDPS, but unfortunately she is sick, but she's replaced in a fantastic way, I'm sure. The concept of doing this virtual has also its virtues, and these virtues are that we have now quite a number of participants, more than 200 registered, and I see that also the numbers of actual participants is going up. We are at 70 now already, so that's great, and it makes it very nice to do this, and I hope this will be a nice and interesting debate. I think it will be a nice debate. Part of it will be, the start will be the paper written by Professor Christopher Kuner, but also we will discuss the guidelines of the EDPB, which are now for public consultation, the guidelines on the relationship between Chapter 5 of the GDPR and Article 3.2, or the other way around, because if you look at the GDPR, it starts with Article 3.2. And also EU law blogs written by two of our distinguished speakers here recently in December on the EU law blog. That it might be a nice debate also about EDPB guidelines is clear because not everyone thinks the same. If I look at the conclusions of Svetlana, she tells us that the guidelines are an important step towards clarity on the scope of Article Chapter 5 and its relationship to the GDPR rules on territorial scope. However, Professor Kuner says the guidelines are not the EDPB's finest hour. They are unclear and they show gaps. So you can see not everyone thinks the same, and that's exactly the idea which I would like to highlight at the start of this discussion. Let me say a few things on the topic itself. I think the guidelines show a few things which are quite interesting for discussion. For instance, the guidelines state that in order for the transfer rules to apply, there should be a controller within the European Union. I think that's a part of the debate. Another part of the debate should be about identifying risks, about essential equivalence, restrictions of transfer, things relating to, and I think that's mainly the topic of Svetlana, will be about trade. So there's quite a lot which will be discussed. Trade issues are also an important part of this whole discussion. Olivier told me that he will speak on his personal capacity. That's another thing which I would like to mention. So he is, although he participated in the EDPB guidelines, he's not speaking in the name of the EDPB. Let me, as a start of this short introduction, say a few things myself. I'm doing this as part-time professor at the VUB, but I'm also in my main daily life, I'm a member of a data protection authority, and I'm dealing with enforcement. And I think the issue which we're discussing here is basically much about enforcement. How can you ensure enforcement of the GDPR once data are outside of the scope, outside of the European Union? Those are what questions when you look at Article 3.2, for instance, of the GDPR, which claims that there should be a representative. So the representative could be possibly the entity to which you could enforce when a controller is based outside of the EU, doesn't have an EU establishment. But for instance, what is the question if there is no representative? How can you enforce then? That's one question to be discussed. Another enforcement issue is that there is, if you look at Article 3.1 and Article 3.2, there is a sort of gap. Article 3.1 should set that Article 3.1 applies when processing takes place in the context of an establishment in the EU. Article 3.2 says it applies when a company does not have an establishment in the EU. But there is, of course, the other case when a controller has an establishment in the EU, but the processing does not take place in the context of this establishment, but takes place in a third country. All questions relating to difficult enforcement, and I think that's one of the angles we should tackle, apart from, of course, and that's the starting point, is the theory and the nicely written theory and which we of Professor Kuner and the others, and also of the EDPB, where we should also think, I think, the case which is mentioned by everyone, I think the famous case of Maria who buys things in Singapore and how is she protected if she buys online in Singapore. That's what questions which we'll discuss, and we hope that Maria will be properly protected when she buys things in Singapore. That will be hopefully the outcome of this discussion. As said, we start with the two intervenants, the two discussants who critically looked at the work of Professor Kuner. And at first I would like to give the floor to Svetlana Yakovleva. As said, she works mainly for the University of Amsterdam and also for the Brouw, the law firm also in the Netherlands. Svetlana, the floor is yours.
Thank you very much, Hilke, and thank you to Laura and Mohammed also for inviting me today. I also would like to mention that I speak here in my personal capacity because this is a very controversial topic, and these are the views expressed today are my personal views. I have prepared a presentation which I will share. Can you see it now?
Yeah.
Good. My goals today are to comment on Professor Kuner's article, but at the same time also to put this article in perspective in light of the EDPB's draft guidance defining the notion of transfer and commenting, as Hilke said, on Chapter 5 and Article 3 relationship, and to raise critical points and questions. I must confess that this part is quite challenging for me because I'm a big fan of Professor Kuner's work, and I look up to his work. He's one of the most quoted authors probably in my own PhD dissertation. But I will do my best to make sure that we have a productive discussion and some controversial points. I will raise some controversial points. As a theme of my presentation, I chose indeed the title of Professor Kuner's other article, Reality and Illusion in EU Data Transfer Regulation. And I think this very well describes the whole controversy around data transfers, definition of transfers, relationship between different parts of the GDPR, and the enforcement problems, because we always aim for a maximum, but overlooking what's happening on the ground and the reality might actually undermine that high goal of providing effective and complete protection to individuals. Here are the 5 questions that I will go over during my presentation. First is what Article 3 rules really do, and I think it's important to also dive a bit deeper into the goals of this article to discuss its relationship with Chapter 5. Is there a conflict between Article 3 and Chapter 5 to begin with? Is there anything missing in Article 3 protection? And if there is a conflict, who should rectify it? Whose job it is to restore consistency of the GDPR that could be undermined? What kind of personal data transfers are out there? I think it's also important to have a clarity on how Europeans' data travels outside the EU and who are the actors involved in these transfers. And finally, the key question that also Hilke highlighted is, are data transfer mechanisms capable of fixing the enforcement problem that may arise in Article 3.2 situation? Because, of course, the whole reason of applying Chapter 5 on top of Article 3 is to enhance enforcement when GDPR applies extraterritorially. On the first point, the goals of Article 3, in his article, Professor Kuner explains that the goals of Article 3 and Chapter 5 are the same, and that is to prevent circumvention of EU data protection standards when EU data is processed abroad. I would like to add an extra point here and an extra goal for Article 3 from the EDPB guidance on territorial scope. And that is that Article 3 also aims to ensure a level playing field for companies active on EU markets. So one of the goals of Article 3 is also to make sure that European companies that have to bear the burden of complying with the GDPR are not disadvantaged vis-à-vis foreign companies that can transfer and process the same data while being abroad. But at the same time, I think on this point, from the level playing field goal in the broader framework, also taking into account trade law, is that there's no disadvantaging the other way around. So neither European providers are disadvantaged, but also foreign companies that transfer data from the EU should not be disadvantaged vis-à-vis their European competitors, unless this is necessary and that it can be justified by the EU in compliance with its trade obligations. My next point is a possible conflict between Article 3 and Chapter 5. I agree with Professor Kuner's thesis in his article that standards of protection under Article 3 and Chapter 5 are not the same. For one thing, standard under Chapter 5 is essentially equivalent protection, so not the same protection. And that affords some flexibility in the design of that protection. However, Article 3 applies the GDPR in its entirety and the GDPR rules themselves. So does Article 3 then provide a higher level of protection? The answer from Professor Kuner, and I also agree with that not really. The problem is, of course, that the enforcement is harder outside the EU. And when Article 3 applies, it is harder to enforce the GDPR outside the European Union. At the same time, Article 3 seems to export a bit more. Chapter 5 seems to export a bit more than Article 3. Although the standard is essential equivalent protection, but that standard includes not only the rules of the GDPR, but the broader framework of the EU, as the EDPB also mentioned in its guidelines, and Professor Kuner explained that the GDPR in the EU functions differently than outside the EU, because the broader legal framework that is informing the application of the GDPR inside the EU is not readily available abroad. So some parts of it might have to be exported through Chapter 5 rules. That is my interpretation. Next next question is, who should rectify the conflict and the overlap, and how? So now we agreed that there is some overlap and the potential conflict, but then whose job it is to make sure consistency is restored. As Professor Kuner rightly notes, Chapter 5 may not be simply disapplied in its entirety by virtue of interpretation, because when the GDPR applies extraterritorially, it applies as a whole. What's the reason to say, okay, we apply extraterritorially this part, but not the other part? However, this is exactly what the EDPB does in its guidelines, by saying if personal data is transferred directly, irrespective of whether the recipient of data is subject or not to the GDPR, Chapter 5 doesn't apply. So in other words, when data travels to a foreign company directly from an individual, in the Maria example, and company falls under the GDPR, somehow Chapter 5 miraculously escapes from that part, from that entirety of the GDPR. Second point is that a reform of data protection law is needed, and that the legislator should step in to restore the consistency and to explain how the two blocks of rules apply in international context. And Professor Kuner proposes two options of such reform. I will not talk about this. I assume everybody read the article. And finally, as I mentioned in my blog, the EDPB guidance starts an important conversation, and I think it has succeeded in exposing a lot of controversies and a lot of unclear points and gaps to start a conversation, and I think it should transition towards a legislative solution. So the EDPB cannot put an end to this saga, because for one thing, its opinions can be challenged in courts, and the courts might arrive to different conclusions, leading to a diversity of interpretations. Next question is, what kind of personal data transfers are out there? I think when I read the EDPB guidance, my impression is that for some reason, the EDPB assumes that the transfers directly from individuals are only a small part, and it doesn't really matter that Chapter 5 doesn't apply. We shouldn't even bother about it. But in my view, it might be that a lot of data actually travels through online monitoring, for example, travels directly from individuals, and it's very opaque which routes and how that happens in reality. This little infographic is based on the EDPB guidance. And in my view, there are 4 situations that result from the guidance, in which situation the level of protection afforded to personal data is different. So in one case, and in the orange frame, you see the type of transfers that are not considered a transfer by the EDPB, and therefore Chapter 5 doesn't apply in those situations. So you can see that personal data can travel from individuals to a company that falls under the GDPR. So then there is protection of extraterritorial scope, but not Chapter 5. It can also travel from individuals to a company not subject to the GDPR. This is hypothetical. Maybe there is no such option, but I think companies try to escape Article 3.2 as much as they can. So I think it's possible. And here there is absolutely no protection whatsoever to individuals. And this is also the most dangerous situation, that the individuals might not even know actually whether the recipient that collects their data falls under the GDPR. And then next 2 situations is a company exported to imported transfer. In one case, the importer is subject to the GDPR under Article 3.1, and Chapter 5 applies by virtue of EDPB guidance. So here we have maximum protection. And the fourth is when data travels to a company that doesn't fall under the GDPR, Article 3, but must comply with Chapter 5 rules. So there is some protection, but not as much as in situation under 3. So my main point here is that first, Chapter 5 the EDPB's conclusion that Chapter 5 does not apply when data is collected to individuals is contrary to the goal of the GDPR to ensure effective and complete protection of individuals. But also it creates an inconsistency from international trade law perspective, because international trade law requires that restrictions on data flows should be the least trade restrictive. If you leave a loophole, such as direct transfers to individuals, saying, well, either just Article 3 is enough or no protection whatsoever, then how do you explain that protection, maximum protection is necessary in a situation 3, where data goes to a company that falls under the GDPR and must comply with Chapter 5 as well. So this inconsistency creates a problem from a trade perspective as well. In addition, from an EU law perspective, in precisely situation of direct transfers, the enforcement problem is most severe. So if the idea behind applying Chapter 5, in addition to Article 3, is to enhance enforcement, then this is not a success. And especially because risks to fundamental rights of individuals are highest, there is no nexus in the EU whatsoever. There is no exporter, there's no establishment. You cannot enforce at all. And I will not touch upon the representative. I hope that Olivier will talk about this a bit more, or we can discuss it later. Then also such approach disrupts the level playing field between companies, because in some cases, companies that have an establishment or have an exporter, they are disadvantaged vis-a-vis other companies that don't have any nexus in the EU, and creates an incentive to actually reroute the data transfers, avoiding the data exporter, or not having an establishment in the EU at all, which is again contrary to the interests of the individuals. And finally, I would like to recall that enforcement under Chapter 5 itself has been subject to multiple criticisms in the past, including in the work of Professor Kuner, but also other scholars, showing that the DPAs have not really enforced Chapter 5, and the mechanisms under Chapter 5 might not be themselves effective to ensure essentially equivalent protection. And I think the two Schrems cases show that the CGU has to step in, that the enforcement system is not working. So to conclude, I think, and this in my opinion, transfers of personal data must receive the same protection, irrespective of technicalities. So the same data of the same individual traveling abroad should travel with the same protection, irrespective of how technically the transfer is routed, because the focus on technicalities also adds an extra step of fact-finding. It's not always so easy for enforcers or individuals to even understand how technically the data is transferred. And also a different protection disturbs consistency from EU law and trade perspective. I think that Article 3 and Chapter 5 should not apply simultaneously, and that there should be more granularity in how they coexist. So I agree here with the proposal that legislators should step in, and that the GDPR itself should be enhanced for situations of extraterritorial application, rather than adding Chapter 5 on top of extraterritorial application. So here it's also necessary to understand the difference between Article 3 and Chapter 5 protection, and to be clear on what the elements actually are conflicting and what's missing if you disapply Chapter 5. And finally, I think that's relates to a broader discussion on enforcement in the context of international transfers, is that additional enforcement mechanisms might be necessary for situation where there is no establishment or data exporter. I don't think that any Chapter 5 mechanism could be more effective, or could actually fix the lack of enforcement, because if companies abroad, even if you apply Chapter 5, you still have to enforce the decision abroad, which could be problematic. So perhaps the mechanisms that are available in copyright or illegal content measures could also be considered in the context of data protection. That's my contribution to the discussion. Thank you very much.
Thank you very much, Svetlana. That was very helpful. Could you maybe just, your last point was the mechanism of copyright could help us. Can you enlighten us maybe a little bit about it? Because I'm afraid that we are a lot of specialists on data protection here, but many of us don't know what mechanisms exist in copyright. Maybe just in a few words.
Yeah, well, I haven't done the analysis, and this is just an idea that I want to throw in the discussion. But what I mean is that if there's a violation of copyright, that there could be some blocking measures, for example, or if in a situation of illegal content, there could be some ways of actually removing that content. So I am thinking whether it is possible to have measures like this in a situation when there's no EU nexus for the company collecting data. But this is more of a wild thought than a recent proposal. So I'm just trying to be provocative and to provoke the discussion. That's all.
Okay, I think that's fine. That's exactly the point of our discussions here, that we should be able to be provocative. The answer will come probably from Professor Kuner later, or not. Olivier, I think the time is yours. Thank you very much for stepping in last moment. Olivier is Head of International Affairs at the EDPS, and he was also involved, I presume, with this famous guidelines. But Olivier, please give us your thoughts.
Thank you very much, Ilke, and good morning to everybody. And thank you also to the organizers for the invitation and the opportunity. And indeed, I will try to step in and replace my head of unit, Anna Burta, who couldn't make it today. I will start by recording that indeed the EDPS, European Data Protection Supervisor, is full member of the EDPB, European Data Protection Board. And on behalf of the EDPS, I indeed had the honor to be involved in the elaboration of the Article 3 guidelines, and also in the elaboration of the guidelines on the interplay between Article 3 and Chapter 5. But as you mentioned before, Ilke, today I'm making comments only in personal capacity. I'm not representing in any way the EDPB or here to defend or present the EDPB guidelines. I'm here to comment and make critical comments to Professor Kuner's article, and I would say also to Professor Kuner's blog, a recent blog in reaction to the EDPB guidelines on the interplay. This being said, I think that on this topic, perhaps even more than on others, I think we need to exchange and benefit from external expertise. And this is made through such articles, through this event. So thank you again for this. And I think that EDPB and its members can only benefit from such dialogue with external stakeholders. Let me also, of course, recall that there is a public consultation that is ongoing on these guidelines until the 31st of January. And of course, it would be important, in my view, for the EDPB to receive contributions to help to possibly improve the document if there is room for improvement. And I would say also to receive practical suggestions and solutions to improve the document. Now on Professor Kuner's very insightful article, I just wanted to make a few remarks at the beginning. First, to say that I think I share very much the view of Professor Kuner that indeed the interplay question is an awkward secret. And I think, Professor Kuner, you very elegantly define what is an awkward secret. It is something that is known, but not discussed because it is too difficult or embarrassing. And I think that that's why your article is so important. And this article provides a very important historical perspective on the evolution of the legal framework, both on the territorial scope, but also on the notion of transfers. And I think that reading this article, you just realize that we went a very long way since '95. And for instance, the evolution of the territorial scope of the European Union data protection framework is a perfect example. We departed, you all know it, from the not easy notion of equipment towards the notion of targeting of data subject in the EU. And I think with the clear intention to avoid any possible gap in the protection. As this objective been fully achieved, this is of course certainly a topic for another debate and another discussion. But I think the article also provides a wonderful panorama of the questions raised. and issues at stake, and in particular, a needed reminder of the respective roles played by the different notion. So the territorial scope and the protection under Chapter 5, they follow the same goal, so protecting personal data against threats originating from outside the EU, but they are not the same and do not play the same role. I think that this article is also very important because it's a strong plaidoyer in favor of a cumulative application of the rules on territorial scope and on transfers. And so practically of a cumulative application of Article 3.2 and Chapter 5. I think that the article was also very interesting because it provides a very constructive and very pragmatic way forward. And I like when it goes to the practice, and including, and that's worth noticing, proposals for a possible update of the GDPR. But if you allow me for my intervention today, I would like to focus more specifically on three aspects of the discussion. First one is, do we need a definition of transfer? Second, did we define correctly the scope of Chapter 5? And third, enforcement. So I will start with the first one, with, I think, quite a provocative thought is, do we actually need a definition for transfer? And was the EDPB the right body to formulate a proposal and guidance? And this is a fact. We all know that both the directive and the GDPR do not contain any definition of transfer. And we could possibly consider that this is a deliberate choice from the legislator, that the legislator had good reasons to do so. Also, it's worth noticing, and it was recalled in the article, that the Court of Justice never gave a real definition of transfer. So one could argue, and it is argued, that the EDPB should not have issued any paper on the interplay, or at least should not have proposed any definition. But let me say also that on the other side of the coin, there were a lot of expectations from stakeholders towards the EDPB. I remember this was very preeminent in the public consultation in reaction to the Article 3 guidelines of the EDPB. There were a lot of requests to clarify this aspect. There were also a call from Commission for the EDPB to issue guidelines on these questions. And I think the private sector, public sector as well, needed clarification on very important questions. Cumulative application of Article 3.2 and Chapter 5. Does the sending of information by a data subject to an entity outside the EU constitute a transfer? We could also speak about the famous example of the employee. This is George in the guidelines. And I think that here the EDPB tries to provide clarification. And of course, we can have a discussion whether this can still be improved. But in my view, clarification means more legal certainty for entities. And I think it is the role of the EDPB to issue guidance to harmonize the interpretation of the GDPR and to harmonize the implementation by entities, the interpretation by DPAs. And of course, we all know that the Court of Justice might one day impose another interpretation, and EDPB and DPAs will follow the case law. Perhaps also one day the legislator will step in to provide further clarifications or solution. But in my view, this will not happen overnight, and still we need to live with the current system. So here, I think we need more legal certainty already today. So perhaps my provocative question to Professor Kuner is, do we need a definition of transfer, or should the EDPB remain silent on this and hide behind this, what you call the awkward secrets on this important question of the interplay, to the price of a possible confusion and legal uncertainty? So that was for my first point. Now let me turn to the definition of the scope of Chapter 5. Of course, the EDPB paper is more a paper on the scope of Chapter 5 than on the details of Article 3. And that's, of course, absolutely normal because there are already other guidelines on Article 3. But when it comes to the scope of Chapter 5, I think there were two main approaches that were possible. A first approach was to focus on the notion of jurisdiction. So basically considering that there is a transfer when the data leaves the jurisdiction of the GDPR. So the direct consequence here would be that Chapter 5 does not apply for the sharing of data to an entity subject to 3.2, because still GDPR applies to this entity. The other main approach that was possible, in my view, was a more territorial interpretation. So there is a transfer when the data leaves the territory of the EU to a third country or is shared to an international organization. And I think I hope I didn't understand, I did understand correctly, but I think that Professor Kuner, you have been clearly advocating in your article for a more territorial application of this question, so leading to a cumulative application of Articles 3.2 and Chapter 5. And I think that this is also the interpretation put forward in the EDPB interplay guidelines. And I would say also it's one of the main outcome lesson clarification of this guidance. Of course, some academics, practitioners, policymakers, judges one day may disagree with this approach. But in my view, this is a clear consequence first from the title of Chapter 5, speaking about transfers to third countries and international organizations, and also from the different arguments clearly developed by Professor Kuner, and I will not repeat them. From a policy point of view, I think that disapplying Chapter 5 to Article 3.2 entities would have been an incentive actually for entities to locate themselves outside the EU and to do some monitoring of the EU citizens. So this is another reason to favor the territorial interpretation. But of course, and that's I think the main point for me, the territorial interpretation leaves us also with additional questions. I think the first question is, what safeguards are required under Chapter 5 for an entity already subject to the GDPR? I think that not all the traditional safeguards that we have in SCCs or administrative arrangements are relevant. And here, I think that the guidelines do not provide all the solutions, and we will need more specific tools, possibly new SCCs, possibly ad hoc contractual clauses. And I think this also explains the limitation of the scope of the recent SCCs issued by the Commission. They do not apply when an entity is subject to 3.2. I think another question, and this was also explained by Svetlana, is what about the case of direct collection of data by an entity outside the EU subject to 3.2? In Chapter 5, if you have no controller, no processor in the EU to act as exporter, that's the example of Maria in the guideline. Here, EDPB clearly took the position that this is not a transfer. And I have seen and heard that this choice was criticized, but we could also consider that this scenario is the main raison d'etre for having the targeting criterion and Article 3.2. And moreover, my question here is, what would it mean in practice to apply Chapter 5 in such scenario? I've seen in your blog, Professor Kuner, that you're referring to codes of conduct and certification. But my provocative question is here, will it be a real solution for these cases to provide additional safeguards? And I would say that this example also leads us to another more general question. What are the legal consequences that we attach to the qualification of transfer? You could possibly opt for a very broad definition of transfer, including also the employee, that's George in the guidelines, including Maria in the guidelines, including also possibly some intra-group disclosure of data within the same controller to a local branch outside the EU. But then the question is, what consequences do you attach to this qualification and what tools do you require? I'm not sure there is a lot of added value to apply Chapter 5 to these cases if you consider that there are no safeguards to put in place to ensure the essential equivalence of protection. I think that part of the difficulty we are facing also comes from the fact that historically, Chapter 5 has focused and evolved around the notions of adequacy, SCCs, BCRs, administrative arrangements, derogations. And especially under 46, all the tools were conceived around the presence of an entity acting as exporter in the EU. So the question is, are you calling now the EDPB to depart from this approach? Also bearing in mind the chapeau of Article 44 of the GDPR, bearing in mind Recital 108 of the GDPR that clearly refer to a controller and a processor. So in other words, do we consider that Chapter 5 should be the law of every move of data outside the EU? So we see new scenarios that are emerging, transfers from processors to controller transfers to an entity subject to 3.2. And I think that here we need to be creative and use further the toolbox offered by Chapter 5 of the GDPR. And I would say that this is not only the responsibility for the Commission, the EDPB, the DPAs, but it's a collective responsibility. And we need also private actors to come up with some new solutions to develop and give full potential to codes of conduct and certification. We need certainly more types of SCCs, ad hoc contractual clauses. I think an interesting question when I read some articles in reaction to the EDPB guidelines was the question of the intentional element to characterize a transfer. Do we need to say more than the EDPB said, that it's mainly about disclosing or making the data available? And here, I think it would be interesting to listen from stakeholders, especially during the public consultation on this precise question. A last topic I would like to address shortly, if I still have time, is the question of enforcement. So what can we do better, or how can we enforce against entities outside the EU? And what is the role of Chapter 5 in that discussion? I think we all know the main rationale of the GDPR, recalled also by the Court of Justice: protection must travel with the data. And I think Professor Kuner very rightly recalled that the protection does not derive from the sole fact that you declare that an entity in a third country is subject to 3.2. First, the entity might not even be aware of its obligations under the GDPR. And to some extent, the territorial interpretation of the scope of Chapter 5 may be seen as a safeguard to facilitate enforcement towards entities subject to 3.2. And this is because many transfer rules can also be enforced against the data exporter in the EU. So when it comes to purely 3.2 situations, I'm personally not aware of many enforcement actions taken by DPAs or decision by the courts against entities subject to 3.2. And I would say that primarily, in terms of priority, also DPAs focus more on entities subject to 3.1, so having an establishment in the EU. And I think that this is because enforcement against entities outside the EU is, of course, that's obvious, a complicated journey. And I would say that this is not at all specific to data protection. The traditional channels of judicial cooperation are very long, very cumbersome, very complex, in particular for DPAs, especially when you need to get a judicial decision or seek the recognition or exequatur of such decision. But I still believe that a lot can be done through a more effective cooperation among DPAs from all over the world when there is a DPA in the third country. And we all know the very interesting work that is done by the Global Privacy Assembly. There may be bilateral cooperation among data protection authority, and that could be a tool to be further developed to facilitate information gathering, the drafting of investigation reports, etc. But indeed, I think it's a challenge and a risk that we need to avoid, let's say, a massive non-compliance under Article 3.2, so that this article will be largely ignored by entities outside the EU. And it's also recalled by Professor Kuner, there is this obligation, of course, to appoint a representative under Article 27.1 of the GDPR. This was precisely designed to overcome the lack of direct enforcement power against the entities in the third country. But it's a fact also that this obligation may be largely ignored and that it's difficult for the DPAs to control this aspect. And we all know also that there was a debate on the liability of the representative, and that the EDPB also already took position on this debate, stating that the GDPR does not establish a substantive liability of the representative. So here, the representative is an important element, but I do not think it can fully compensate and completely compensate the difficulty to enforce against entities subject to 3.2. And I think this is also why it's so important to continue to apply Chapter 5 requirements to entities outside the EU, but subject to the GDPR. And I think that's it. I don't want to take more time. I was probably already too long, but these were the three main points I wanted to discuss, and thank you very much for the attention.
Thank you very much, Olivier. Indeed, we're running a bit of more time, using more time than we expected, but this is very interesting, all the questions. I think I will not take time myself. I think Chris, Professor Kuner, maybe you can briefly come back on the many, many questions that's been asked to you. Please take the floor and please give your views. Afterwards, I'll give the floor to the audience.
Yes, well, thank you very much, Hilke. And first of all, I'd like to thank all the discussants for their very useful comments. I know you're all very busy people, including our moderator, and I'm grateful that you've taken the time. And I'm also, as an academic, I think, as a legal academic, we're always feel very flattered when just the fact that anyone ever reads what we write, because, you know, we tend to publish things in law journals and very few people ever look at them, and they go into libraries. So just the fact that you've taken the time and we have so many participants, really, I'm honored by that. I think I would make a few, try to be fairly brief in my points, and then turn over to discussion. One of the important points is with both my paper and my blog entry, I really was trying to kick off a discussion of the issues being dealt with today. I hope I didn't give this impression in my article that I had some kind of complete set of answers for these issues, but I really wanted to be a bit provocative and start the discussion. And I'm certainly that seems to have happened. So I'm very happy that at least my article had that effect. I also want to, as Hilke said at the beginning, I said, well, this guidance of the EDPB wasn't its finest hour. That doesn't mean that I think everything in it is bad or that it's necessarily terrible. I think there are some things in the paper I agree with. It's our function as academics to make critical comments. So I think that's really our added value. And certainly I don't think this was the best paper of the EDPB. I think some of the papers or guidance documents are quite good, but this was one that I had some issues with. And I was also provoked by the fact that I know that even though there's been almost no discussion of these issues in the relationship between territorial scope and data transfer rules over the last few decades even. And in fact, I think that in many cases, in talking to DPAs in the past, I've had the impression they've really tried to push away these issues because it's too difficult. But there has been, I know, a lively debate going on in the EDPB in the last few years over this, and I think it's worth saying that this guidance probably, there was quite a lot of division in the EDPB, and the guidance sort of reflects that. But there's also interesting publications from the UK ICO and the New Zealand DPA on this issue, where they took kind of more drastic views, saying very clearly that if our law applies directly, then you don't really have to worry about data transfer. So I saw a bit of a trend developing, and I thought this is an important moment maybe to step in and start to start a more open discussion, because a lot of this discussion seems to have been carried out sort of behind closed doors in meetings of DPAs, and also in the commission. We should say that the commission has also kind of taken positions on this in the new SCCs and in the Korean adequacy decision. So it's important to air all this and get it into the open. Another point to note, of course, my paper was published in April 2021. There's been a lot that's happened since then, and I'm currently working on a revised version, which I will try to have published in a law journal. So maybe my article has been a bit overtaken by events. And in particular, it doesn't take into account the new SCCs or the adequacy decision, nor does it take into account the EDPB paper. That's something I'm going to have to work on now, the new version. And then again, I would point you to the blog post that I published in the European Law blog on 13th of December, and on the EDPB guidelines, and also the blog of Svetlana on the same topic in the European Law blog, which I agree with greatly. So I really commend that you read that as well. So I'd like to, again, not take up too much time, but I'd like to just make a couple of points, maybe not dealing, I will respond also maybe briefly to some of the comments before I go further. Yeah, Svetlana makes very good points, I think, in particular about the trade issues, which I have not dealt with in my paper because it's not a topic, international trade law, that I know anything about. But that's also an issue which I think needs to be looked at. And I think it's kind of striking that I think the EDPB in the past, in its Article 3 paper, said, well, this issue of Article 3 and Chapter 5 could have trade law implications. So I guess that was one of the reasons that you dealt with it in the guidelines. But then on the other hand, Svetlana in her blog says, well, this could violate trade law. So this is maybe something that you need to really look at very carefully in the EDPB, that you know, whatever positions taken don't have kind of the opposite effect of what you intended. So that's very useful. And then Olivier has raised some very good, very provocative questions. First of all, do we need a definition of data transfers? A few years ago, I would have said absolutely yes. And now I've sort of taken, I'm sort of 50-50 on this issue, because I think the Court of Justice has kind of been able to address, looking, for example, at the Schrems cases, data transfer issues very effectively without a definition of data transfers, by simply focusing not on a kind of definition, but by looking at the purpose of the data transfer rules, which is to provide protection against external processing of the data. So I certainly think, you know, it's probably, I can certainly see the case for having a definition. I'm not completely sure that it's absolutely necessary, but I see the case for it. And I think it's like many of the issues, or all of the issues we discussed today, it's something that needs further discussion. Olivier raised the point of legal certainty for stakeholders. Well, this is a general point I have that also goes to kind of lack of transparency. I wonder, who are these stakeholders that have been saying all these things? We need you to clarify this. I just as an example, for example, I noticed that in the Commission paper on revision of the GDPR, they said, well, in our consultation, many stakeholders have raised this point. And so it's something to look at. And so I went back and read all of the consultations documents that were submitted to the Commission. I think there were like 130 of them or so. And I found only sort of 2 cases where these stakeholders had actually said this is an issue, and there was only one of them, I think, that went into any sort of detail. A couple of them just said it's an issue, you should deal with it, but they never really explained why. And this is something I think we lack, is there's never really, to my knowledge, been any granular, detailed investigation of what are the implications, the practical, real-world implications of having a cumulative application of Chapter 5 and Article 3 together. How many data transfers are there? How many cases of direct application of the GDPR are there? And in how many cases do they overlap? That's never been done. So we're all kind of dealing with this theoretically, and then of course, you know, a lot of companies would very much like not to have to apply Chapter 5. But to my mind, this isn't really sufficient. We need to go into a lot more detail, probe more deeply, and not just say, well, stakeholders are asking us for this. And I'd also like to see these discussions with stakeholders be a bit more open, so we could evaluate them. Cumulative application of the two. I suppose that I try always to be a careful lawyer, and I try to be guided by the text of the GDPR and the object and purpose of the provisions, which is the test the Court of Justice uses. And it seems to me, based on those, that there should be some cumulative application of the two. Now, in a perfect world, I think this should have been dealt with in the drafting of the GDPR, and there were some of us who raised this point and tried to make proposals, but they were not taken up because it was felt that this is just too controversial. So ideally, we would have one set of provisions dealing with external threats to EU data processing, which could kind of merge these two mechanisms, Article 3 and Chapter 5. And I certainly agree, you know, we don't want a lot of unnecessary duplication, but on the other hand, there are a lot of provisions in the GDPR that have the same underlying policy. And so it's a kind of belt and suspenders approach. This is something else that I find interesting, that many of the positions I took in my article were actually things that I learned from DPAs in the early years of the directive, saying that there has to be a cumulative approach because, you know, belt and suspenders. Article 3 doesn't capture all threats. Chapter 5 doesn't capture all threats, but together they can provide for enhanced protection. So I certainly think there's a case to be made that at least some provisions of the two should apply simultaneously. That doesn't mean that everything has to apply together. And then, you know, applying these protections in practice, yes, this is an issue. And I don't think neither Article 3 nor Chapter 5 can provide perfect 100% protection. And this is not because of them being bad, but it's a consequence of the world we live in. And you know, the International Law Commission of the UN has said one of the chief elements of the international legal framework is fragmentation. So it's the same as consumer protection, any sort of situation where there are parties outside the EU dealing with people in the EU, you can never have perfect enforcement. But I think what we need to get to is a kind of a satisfactory level where at least we feel like there's a good way of enforcing the law, and this is probably, a lot of this has to be done unofficially by cooperation between DPAs. So with that said, I'd just like to point out a couple of things before I turn the floor back over to Hilke. Really, the issues we're dealing with here are not just technical legal issues. There is a lot of technical legal material here, but this really gets to the protection of EU data against external threats, that is processing outside the EU or transfer to parties outside the EU. So we have to see this in a broader perspective, and we do need certainly a clear understanding of how these two sets of rules interact. And we're really suffering at the moment by the fact that the GDPR doesn't really say anything about this, and it's not ever been dealt with by anyone that I've been able to find. It's been completely neglected. In fact, I even found in my files, this is a paper by the European Commission from November 2001. And I think many of you on this call, you probably were in elementary school in November 2001, except for Hilke and I, we're the kind of old timers here. But the issues were realized and dealt with from the early years even of the directive. This is over 20 years ago, but no one has ever mentioned them now. And I think what we also have to do is be very meticulous and rigorous in examining the relationship between Article 3 and Chapter 5, and we can't sort of decide what we want the result to be and then say, okay, let's interpret the law to reach that result. We have to see what the text says, what the policy says, and where does this lead to us? Where does this lead us? I do find both the guidance of the EDPB and some of the positions taken by the Commission to be contradictory, to not really be fully explained in their relationship to the text of the GDPR. And this is what really disturbs me the most. Is I think as lawyers we have to be always meticulous and rigorous. And when I get the sense that we're kind of, those standards are being watered down a little bit, then this is when I worry. Finally, I would say I do think two things we need. One is greater openness in discussing these issues. The EDPB certainly has a very important role to play because this is where people look to for interpretation of the GDPR. The Commission also has an important role to play in its decisions, and we need really open discussion about this. And this can't just be sort of internal closed-door discussions among DPAs and EU institutions. We need to have an open open gathering of information and discussion, because I think otherwise it does raise questions of sort of democratic legitimacy, particularly when it's possible that the protection afforded EU data, which the Court of Justice has said is very important, we can't water this down. So this argues for an open discussion. And secondly, as I said in my paper, really this needs to be it needs to be dealt with through some revision of the GDPR, whenever that is. I mean, I spoke to a former DPA about my article, and this person said, this is never going to happen in my lifetime. And this may be, unfortunately, the case. This may be just too much of a political hot potato, but this is what sort of maybe my biggest disappointment with the EDPB guidelines was just that this wasn't said at the end of the paper. Whatever positions the EDPB took, I wish at the end it had said, you know, these are very complex issues. The Commission needs to look at this as a matter of urgency whenever it gets to making decisions about revision of the GDPR. I think that message would be very important. And then with all of these other technical issues, we'll just have to have an ongoing discussion about them because they are very difficult. So that's my reaction. Ben, I just would again thank all of you for participating.
Thank you very much, Chris. Your last point was clear, of course. Basically, you want a new law or change of the GDPR, opening it up. But there were a lot of other very important issues have been raised during this last hour. Of course, a perfect world doesn't exist, but we learned a lot about different issues, etc., awkward secrets about whether or not we need a definition, etc. I don't want to take any time myself. This is, as said, meant to be a discussion session. Is there anyone who wants to take the floor? Please raise your hand and then I will give you the floor. Is there anyone? More than 100 people, so there must be someone having questions. I see Stephanie Faber. Could you please? Yeah, great. We don't see you, but we see the background. But please go ahead and unmute yourself.
I was saying, when reading the EDPB guidelines, it actually shed a new light for me on Article 3.2, because at the end of the document, EDPB said, well, even if you don't have contractual clauses or whatever safeguard for international transfer, you still have to comply with GDPR generally, and notably with Article 48. Article 48 says that you cannot share data with authorities of the third country. But if you're in a situation where you have no establishment in Europe and your only establishment is in this third country, actually Article 3.2 brings the consequence that you are very often we would be in breach either of GDPR or of your local country, because it comes up several times that I don't know, you may retain data for a longer period only if prescribed by EU or member state law. But obviously, if you are in this third country, you will have to retain data based on this third country law. And Article 48, how would there be a cooperation with a local authority, EU authority, if you're not established in the EU? I mean, I think one of the issues is maybe Article 3.2. And the other point was, if you say, I mean, it's a comment on Svetlana's chart on, you know, when it's transferred directly from individuals to the company in a third country. If we had to apply Chapter 5, possibly that would lead to using consent. Is that really the solution? I mean, the individual's consent, because who would you have the transfer tool with? You are going to target them to exceptions, which is not really acceptable. So these were my two comments.
Thank you very much. Could you maybe identify yourself as well?
Oh, yes, sorry. Stephanie Faber. I'm working at Squire Patent Box, which is an international law firm. I'm based in Paris, and I used to work with Christopher in the ICC Data Protection Commission.
Okay, thank you very much.
Thank you.
The point indeed of your first point raised is something we didn't discuss yet, the conflict of law problem. Maybe that's something people would like to react on. And the other point about consent, I do not exactly know if why consent would always be needed, but possibly one of the panel members would give an answer. Please go ahead. Who wants to take the floor? Svetlana?
Oh, sorry, I thought you were asking the audience. Yeah, I would like
reacting on this point on the question raised. Yeah.
Yeah, I would like to react on the question on the second part of the question is if we apply Chapter 5 in the situation of direct collection, then what safeguards would be available. And I have 2 points here. One is that this could also be problematic from a trade perspective to apply Chapter 5 to direct collection, because this would mean discrimination of foreign companies collecting data vis-a-vis their European competitors, because, for example, they wouldn't be able to rely on legitimate interest as the ground for collection. They would need an additional safeguard from Chapter 5, and legitimate interest is not one of them. So it would be more difficult to collect data from abroad vis-a-vis the EU. And so that's why the way I think the issue should be resolved is not through direct application of Chapter 5 altogether. And here I agree with Professor Kuner's options that there should be some blended solution which takes into account different aspects, both from EU data protection and EU Charter perspective, but also the trade component, that in the current situation, if you apply Chapter 5 in addition to everything, there is a discrimination issue. But if you disapply it, there is another issue. So you can't have it one way or the other. That's why some more granular solution is needed. And I think Professor Kuner's article makes a great point on this. And about Article 46, I think that there's nothing in Article 6 that says it should be limited to exporter and importer. It's more the interpretation of the EDPB and the European Commission that, for example, standard clauses are only in the exporter-importer situation, but the GDPR itself says standard clauses, which could be also clauses between the individual and the company that collects their data. I think there is some possibility for expansive interpretation of safeguards in Article 46. This could also be a part of the reform to look at those safeguards and see they might have more potential than they actually are, them beyond what they're used for at the moment.
May I just add on your last suggestion about SCCs that would be signed with an individual? Part of Article 3.2 is about monitoring. So you wouldn't sign anything with people you're monitoring unless you do it the same way you do with cookies. And making it too complex for, I mean, if the end result is that, in fact, we should prevent companies in third countries to do certain things with EU data, then we probably would deprive the EU market from very interesting technology. So just wanted to mention that.
Okay. Anyone else also on the point of conflict of law? Chris or Olivier? If not, I think someone else could contribute to the discussion. Is there anyone on the floor who would like to say something? I see a hand. Right.
Yes, I just unmuted myself. Hello, everyone. And thank you for this very lively, interesting discussion. So picking up on something that Olivier mentioned before about the idea of the representative and the fact that the EU lawmaker decided not to make the representative directly liable when Article 3.2 controllers are in breach of the GDPR. It seems that the EU legislator indeed is rethinking that option in the context of the DSA, for example, because now it does opt for making the representative of online platforms directly liable for their breaches when they have no EU establishment. So the legislative solution to the conundrum could also pass through that. I'm wondering whether you think that could be a solution as well, revising the liability issue. Another difficult question regarding that is, what if the Article 3.2 controller fails to appoint a representative? So that in itself is a breach of the GDPR that then could be very hardly enforced by DPAs, and the extraterritorial enforcement problem would prevail. So I would like to have your thoughts on that too. Thanks.
Thank you very much, Sebastião, who works for the Future of Privacy Forum here in Brussels.
Thank you, Hilke.
Thank you. I think the issue, last point, was already raised before. What if someone doesn't appoint a representative? How can you act as a DPA? A question which I, working for a DPA, don't have the direct answer, but maybe others do. And the other point of liability. Please, who wants to react from the panel? Chris or Olivier?
Yeah, maybe briefly. I mean, I did make this point in my article about the representative. I've never been a great fan of relying too heavily on representatives, because I think there's really a sort of limited use they can have with regard to enforcement. It's not possible. It's just, I mean, it would be outrageous to try to hold the representative personally, liable or throw them in jail because of what their client did outside the EU. But they do have a certain value in terms of communication with the DPA, and this is what I find a bit disappointing, is that there's this mechanism in the GDPR. It was clearly contemplated by the EU legislator as one of the mechanisms by which enforcement maybe could be somewhat improved, but it hasn't really been used at all. And I don't understand why the DPAs, for example, don't try to promote a market for representatives, because at the moment, if you're a company, let's say, and you want to appoint a representative in the EU, it's very hard to even find people or know, are they reliable? I mean, there are a lot of advertisements on the internet saying we'll be your representative, but are these people really reliable, serious, etc.? So there need to be some sort of standards or good best practices, maybe is the term, that the EDPB could promote for representatives, which don't need to be legally binding, but I think they would be very valuable in helping to kind of create a good, better market for these representatives. And then we'll have to see how they work. Again, I don't think, to be realistic, this is going to be a complete solution to enforcement, but we might as well try it if it's there and the legislator contemplated it.
Thank you, Chris. I think this is a much easier solution than changing the GDPR, but it's a good suggestion. Olivier, you wanted to intervene?
No, thank you very much, Hilke. And indeed, I just wanted to complement, and of course, I agree that it would be very important to have a real market for representatives and an easy solution for the entities outside the EU to find a representative. But I just wanted to add that indeed, I think it was not let's say the will of the legislator to have a full liability of the representative. So there is no substitutive liability, but at the same time, and it was recalled by the EDPB, there are still some direct obligations for the representative, such as maintaining a record of processing activities, also on behalf of the controller, or also the duty to cooperate with the supervisory authority. And for these aspects, yes, there is a liability of the representative, but not for any kind of breach by the controller. So indeed, in that sense, I don't think that the representative can compensate all the enforcement issues that we may face. And this was the choice of the legislator. And it's true that in other fields of law, it might be different. So there might be developments where a representative is held liable for everything, if I may speak so. And that's it.
Thank you very much, Olivier. I saw Romain Robert asking for the floor. Romain, could you please unmute yourself?
Sorry, do you hear me now?
Yeah.
Yeah, sorry. Hello, everyone. Just thank you for giving the floor. I just had a little remark and a question. We have a case at NOIB against the Luxembourg DPA, dismissing a case not only because there was no representative in the EU and they could not enforce it, and that's what it kind of implied in the decision, which I think is quite shocking, of course, because the message is basically, guys, if you're not established in the EU or you don't have a representative, you cannot do anything against you, which is basically saying to Google and Facebook, go back to the US, because if you go back to the US without any representative, we will not enforce the GDPR against you. But also more than that, it seemed that the Luxembourg DPA in this case was also not dealing with the case because they said that there was no representative in the EU that they could discuss with. So it's not even about enforcement, it's about the power of investigation of a DPA, not allegedly being able to investigate about, for example, the application of the GDPR against a non-EU company because this company was in the US. Whereas I think that to determine whether the GDPR is applicable or not, you don't need to travel to the US to know whether this company is subject to the GDPR. And that's a little bit what the decision of the Luxembourg DPA implied. We need to go to the US to investigate whether Article 3 is applicable, which I think is crazy. If you can't decide without traveling to the US whether the GDPR is applicable, we are really in a dead end, I think. I don't know if you have any thought about it. It's really like, I think it was a really shocking conclusion from the Luxembourg DPA to say that without representative, we can't either enforce and neither discuss with these people and to determine whether the GDPR is applicable. Thank you. Just a little question remark.
Thank you, Will. Thank you very much, Romain. I see a few more questions, so maybe we collect them for last round and then give also the panelists last round. I think the next one who I saw is Gloria Gonzalez-Fuster. Gloria.
Yes, hello everybody. Very nice to see you and very interesting discussion. I had a question about information obligations related to transfers. And it relates somehow to the question that perhaps we don't need to know what is a transfer. And perhaps indeed we cannot know what is a transfer, but controllers have to inform data subjects in a clear, transparent, easily to understand manner when there is a transfer. So I suppose we have to tell them what kind of transfers they have to inform about. Is it transfers in the sense that we might eventually understand that not all transfers are transfers? So I think it could be useful to clarify at some point how the new version of transfers relates to these transfers under information obligations so that we know what to expect. So could you agree with me, this is my question, could you agree with me that the EDPB should explain this, how to interpret transfer as in Article 13 and 14 so we know what we are supposed to be informed about as data subjects? Thank you.
Thank you very much, Gloria. I see a last hand of Partha.
Apologies that I can't, some problem with the camera here, so kindly pardon me.
Can you tell me who you are in any case?
Yes, my name is Partha and I'm from Bangalore, India. And I am an independent consultant in the data privacy and governance and risk space. My question is primarily a simple one and obviously a practical one. Assuming a company in India, right, and with no establishment in the EU, but of course Article 3.2 applies, and assuming that, a DPO is being appointed, but the DPO is located in India, but still reachable to the EU data subjects. Is there a case that really holds out from a EU law perspective and GDPR that in this particular case, the EU representative still needs to be appointed? Because I believe there is an interplay between the role of an EU representative and the DPO, but assuming that DPO is in India, and easily reachable to the EU data subjects, would it still be required mandatorily for the company? And assuming it's a small company, not all companies have the resources and all of that, it takes money, to kind of still appoint a EU representative?
Thank you
And
very
what would be
much.
the implications if they don't do it? And, you know, sorry, yeah.
Thank you. I think this is a very clear question and a very justified question. What I suggest, we're almost at the end of time, that I give the three speakers, all three, the floor. React please on the questions by Romain of Noib, Gloria of the VUB, and then Partha from India, and then round up. I think three, please give your reactions to these questions and your final remark, and then we finish this very interesting Meet the Author event. I start with Svetlana, then Olivier, and Christopher, you have the last word.
Thank you, Hilke. I will start backwards. So a question from, no, actually not backwards, but I start with a question from Gloria first, and then talk about representative. I do agree, and also Laura Drexler, one of the organizers, she wrote in her article in more detail about the gap in the guidance regarding the rights of data subjects, and I think I agree with Gloria's proposal that it should be clarified how the definition of transfer, if the EDPB decides to stick to the definition of transfer, how it translates into the rights of data subjects, because it turns out if something is not a transfer, then the individuals also will not receive information about that data transmission, which exacerbates the situation of individuals even worse, in addition to the enforcement issues that also can affect data subjects. And regarding the representative, I must say that I'm not a big expert on the topic, but my understanding is that the representative is not a legal entity in itself and cannot be responsible really with it doesn't even have to have assets or anything. So the company is still abroad. It's just a contact person that is in the EU. So I think there are limited enforcement options. I wouldn't say there are no enforcement options, and there's something the DPA should do with the representative instead of saying, hey, I'm just not going to enforce at all. So if there's no representative, I think it's a more difficult situation, because then you have to enforce a decision against a company that has no point of contact in the EU, but they can still make a decision and try to influence the company. And here again, I think it's worth the GDPR is not the only legal instrument that has extraterritorial application. We see this more and more often with different compliance areas, such as money laundering, anti-corruption laws, copyright, illegal content. I mean, there are many areas of law that have, I think, same issues with cross-border enforcement, and perhaps broader comparative research is needed to see whether some areas have succeeded more than others in enforcing against foreign companies. I think also the Google CNIL case on right to be forgotten is interesting, because it also touches upon the issue of enforcement of the right to be forgotten worldwide. And in that case, the court took a more restrictive position that the right to be forgotten should only be enforced in the EU and not worldwide, for example. Hilke, you're on mute.
Thank you. Sorry. I think that was a good addition. What I would like to say, learn, and I just think we should also take in our mind, learn from other areas of law, how they do it there, because we are not the only ones doing these things. Good point, Svetlana, and also other point. Olivier.
Yes, thank you very much. I will try to say a word about the three questions that were raised. First, perhaps to Romain, thank you very much for the interesting question. And of course, I will not comment in any way about the Luxembourgish case. I don't know it in details, but I think that the question you're raising is about the lack of representative and the possibility, when there is a lack of representative, for a DPA to do an investigation report and to establish a breach of the GDPR. There might be cases where it could be possible through live or using online tools to do the inspection, but for others it will not. And so I think here it's again a reason to promote the cooperation among DPAs over the world to facilitate the information sharing, the gathering of evidence, etc. Now turning to Gloria very shortly as well, I think, yes, it's an important point. I think that indeed the definition of transfer, the definition of the scope of Chapter 5 has direct implications in terms of transparency and in terms of what transfers or what flow of data do you need to notify to the data subject. And here, of course, there are some guidance given in the guidelines of the EDPB on transparency, Article 29 endorsed by EDPB. But I would say that your question is an additional reason why we need to try to define precisely the scope of Chapter 5. Because when we define also the scope of the transparency requirements and obligations. So I think that indeed that's a relevant point. And when it comes to PARTA, I would say that the requirement of Article 27 is that the representative should be in the EU. That's quite clear. I think also, I could not retrieve the document right now, that the EDPB took the position that there is an incompatibility between the role of representative and the role of data protection officer. But here I just would like to point to these Article 3 guidelines that were published by the EDPB, because you have many details on who can act as a representative in the EU, and I hope it will provide you with sufficient guidance. And that's it.
Thank you, Olivier. Christopher, the last word is yours before I close it.
Yes, thank you. Well, very briefly to respond to the three questions. First, to turn also to the last question, I have to say I'm very happy to see people on this webinar also from outside the EU and from India. We often forget the global impact of the GDPR, and I think this shows it, and also that the parties outside the EU that fall under Article 3.2 will have a lot of practical questions, which we may tend to forget as we sort of deal in our legal debates here in Europe, in the EU. So I agree. I think what Olivier said is correct, that the function of representative has to be different from that of the DPO, and this was indeed said in the guidelines. There's an incompatibility there, but we need to provide workable, practical guidance for parties outside the EU, or how can we really realistically expect them to comply with the GDPR? Gloria made also a very important point that sort of brought us down to earth. I mean, as I said, I think we've been able to kind of, at least at the high level of EU law, exist without a definition of data transfers, but there's a practical question: how can the parties that have to provide information to individuals do so if they don't know really what a data transfer is? So we need to, that needs to be clarified for sure, I think, so that the information obligations can be meaningful. And then the last point of Romain Robert, I certainly don't want to opine on any particular case or criticize interpretation of a particular DPA, et cetera, but I certainly agree. I don't think that appointing a representative is in any way a precondition for or at least under the GDPR. I don't know what the national law says of a particular DPA, but it certainly shouldn't be seen as a precondition to the DPA investigating a potential breach. That seems to me to be kind of at least to a vicious circle then, where a party falling under 3.2 could just sort of avoid all liability by not appointing a representative, and that's clearly not the intent of the drafters of the GDPR. So that would seem to be a bit strange interpretation. And then my final word is just, again, thanks to all of you on the panel for taking the time, and to those many of you who participated in this webinar. And I guess this is just the first step. I think maybe we shouldn't leave the impression now that the EDPB guidelines and everything is solved. No, we're just really starting the discussion, So please, you know, many of you send your thoughts to the EDPB consultation also. I think that's very important. So Hilke, I'll turn the floor back to you then.
Thank you very much. Thank you very much. It was very informative. I think I don't want to add anything. We're run out of time. I think first, not the panelists, but first the two people behind the scenes who did a lot of work to make this all happen. Laura Drexler and Mohamed Demirkan. I really want to thank you a lot to make this happen and to make this work. Laura's work is not finished because she will provide for a report of this session, which will be made available to all of you and on the website of the Brussels Privacy Hub. Of course, also big thanks to the three panelists, Svetlana, Olivier and Christopher. And finally, this is a series, so we hope to announce a new edition, a new session of the Meet the Author, either hybrid, either online or maybe also once again as an in-person meeting, hopefully in a few months from now. I thank you all. This was great, and see you all, and thank you for participating. We had a lot of participants, which was good, and the level was high. Thanks a lot.
Thank you.